Hello, this is Matt on the Moon Lambeau channel, and here's the headline of a statement put out by acting chair of the SEC, Allison Herren-Lee, which an attorney is speculating is evidence that Ripple actually has been negotiating settlement with the SEC post Jay Clayton leaving. So within the last 4, 5, 6 weeks, there's been potentially some settlement negotiations. Now, as it turns out, if he's right though, and there's a bit of speculation, but I think it was perfectly reasonable speculation, if he's correct in what he thinks is going on here, this particular headline here, statement of acting chair Allison Herren-Lee on contingent settlement offers, although it does not explicitly mention Ripple or XRP, it was crafted exactly because of the SEC case against Ripple, and frankly, would not be good. And so the attorney that is putting out some information about this, it is none other than Jeremy Hogan. I'm sure many of you have become familiar with him to this point. He runs a YouTube channel called Legal Briefs. And so as far as all of the law perspective stuff in this particular video, these are all of his original ideas. And then I'm going to share with you what I think the implications of this are for Ripple, assuming that Mr. Hogan here is correct. I definitely have some of my own original thoughts on that. But I tell you what, here we have Jeremy Hogan flying in with the cape like a superhero, making the complex understandable for us mere mortals. And so he put out a video today where he was talking about this topic. He really broke it down excellently, and he gave me a shout out too. So if you're listening, Jeremy, thank you very much. I do appreciate that. And so if you guys have not yet subscribed to Jeremy's channel, again, Legal Briefs, just type that in the search bar. Legal Briefs will pop right up, and I think that you'll appreciate having done so. He's really on top of all the legal happenings with the SEC versus Ripple. So I want to make sure I give credit where it's due, give a proper shout out, and prop up those that are contributing to the XRP community. And he most certainly undeniably is. So credit where it is due. So let's break this down because it's a little scary. It doesn't mean that it's the end of the world here, but I'll tell you what, after going through all this, I think it's much less likely that we're going to see a settlement. Doesn't mean it can't happen, but I find it rather unlikely. And so here's the thing. So the lawsuit is it's really about ultimately, the part that could be scary anyway. The idea of Ripple, it's the idea of Ripple no longer being able legally to sell their XRP holdings. And so what would happen to the price of XRP if they were no longer allowed to sell their XRP in escrow? Well, I've talked about this ad nauseum on this channel, especially lately. Ripple CEO Brad Garlinghouse has publicly stated that Ripple would not be a profitable company without selling XRP. Now, it doesn't mean that would be the case forever, but when you're building out something as substantial as on-demand liquidity with razor-thin margins, it could take a long time and notable global adoption before that on its own would be sustainable. So in the short term, at a minimum, Ripple being able to profit from its XRP sales is important. Now, of course, they're only selling a small percentage in terms of daily volume, so they're in no measurable way suppressing the price of XRP, but it makes adoption possible. And also, they're taking a bunch of the profits and plugging it back into the XRP ecosystem. You can think about what they're doing through their development arm, which is called RippleX, formerly known as Spring. And really, they're taking a ton of these profits from the XRP sales and just plugging it back into that. And it's funding developers building on top of the XRP ledger. That's incredible. To me, that's to be applauded here. So, to me, that's of crucial importance. Now, there are two parts to the SEC, as noted by Jeremy Hogan. It stated there's a regulatory part of the SEC, and there's a separate portion of the SEC that is the enforcement part. And so the regulatory part passes rules and makes decisions on whether or not a filing is adequate and things along these lines, whereas the enforcement part of the SEC files lawsuits against those that it thinks have broken the law. And so in this document, there's a quote which reads as follows: "The Division of Enforcement will no longer recommend to the Commission a settlement offer that is conditioned on granting a waiver. Now, to anybody that's not a lawyer, that's gobbledygook. You hear that, you're like, what the hell does that mean? I have not a freaking clue, which is why I'm so thankful that Jeremy has broken it down, because there's no way I would have been able to figure out the implication of this on my own, not having a background on this whatsoever. But check this out, and I'll break it down for you. But what's interesting is prior to this statement, which came out just the other day, this was February 11th, 2021. Prior to this, the policy of the SEC was the exact opposite of what was just stated there in that sentence that I just read to you. Under Jay Clayton, he specifically cited that it was precisely the opposite. So why the change? The question is, why the change? Because you've got an acting chair, Allison Herron-Lee here, changing what is effectively a long-standing SEC policy, and she's not going to be here very long. Presumably, Gary Gensler is going to be approved in the coming months, and she goes bye-bye. Why would an acting chair change something like this, and what are the implications, right? Well, the thing about this is, when you've been determined to have violated the law, you can lose certain privileges based on this new policy. Specifically, check this out. Here's another quote from the SEC release. Violations of certain provisions of the federal securities laws give rise to automatic disqualification from exercising certain privileges, including being considered a well-known seasoned issuer, engaging in certain private securities offerings under Rule 506 of Regulation D, and serving in certain capacities for an investment company. And so what she's saying is that that settlements of litigated cases can no longer include settlement terms that include anything related to offers or sales under Regulation D. And so where did we last see Regulation D? Well, it was in the final judgment of the Kick Interactive case, which I've talked about a number of times on this channel. Kick Interactive is a company that got charges thrown at it too, the SEC. And the SEC won, by the way. And so it was basically a slam dunk win. But even under that, they were allowed to continue selling their KIN token. The Kick Interactive had a KIN token, K-I-N. They were allowed to continue selling it. They just had to fill out an exemption form, give the SEC 45 days notice, maybe a couple other things. But they were allowed to do that. And so effectively with this policy change, Ripple, it's actually now a policy of the SEC. Effectively, now it's active. You cannot include such terms in a settlement. So what we were excited about thinking could have happened for Ripple, since it happened with Kick Interactive, no longer a possibility. There will not be a settlement where Ripple is allowed to continue selling its XRP. That's effectively what happened here. So that does sound scary. Now, the timing of the statement likely isn't random, says attorney Jeremy Hogan. And in fact, he thinks that prior to this most recent statement, Ripple lawyers were in touch with the SEC lawyers and probably stated that they wanted to be able to only sell XRP to accredited investors, and also likely would be willing to pay fines for sales that have already taken place. So the part where things get a little scary is that Jeremy thinks the SEC said no to this. Ripple's lawyers then probably went back to the Kick Interactive case and said, hey, look, this is effectively what you've allowed in the past. You did it for them, you have to do it for us too. Ripple likely would have cited discrimination if they were treated differently. And so the SEC doesn't want to be charged with discrimination now, do they? Right? And so what do you think might have happened then? The SEC lawyers likely, then took this information to Allison Lee, again, acting chair of the SEC, Allison Lee, and quote-unquote fixed the problem. You know, like in Office Space when they fixed the glitch with Milton, and he's a guy that was fired in the movie Office Space, and they rather than from some mistake, he just remained on payroll. And but there was no record of him being employed there. And so through a glitch, he kept getting paid, and then he was just like coming into work. And so what they did is they fixed the glitch by just removing him from payroll. They didn't tell him. They fixed the glitch. So anyway, I think that Allison Herron-Lee here fixed the glitch here by effectively just changing the policy of the SEC. Because why the hell else would this have happened right now? You know, I mean, think about this. Because now, look, if this is a blanket statement now. This is blanket policy that applies to everyone, and so thus the SEC would not be discriminating against Ripple at this point. And so the Ripple case, consider this, is the most high-profile SEC case right now. And according to Jeremy, there's nothing else being litigated that would have resulted in a change of this long-standing policy. So this means the SEC would perhaps agree to a settlement with Ripple, but that after the settlement, Ripple would actually have to apply for a waiver if they want to sell XRP ever again. Think about that. So they won't include in settlement terms that Ripple can continue to sell XRP. They won't include that, which means if they agreed to settle and Ripple paid a fine, they could then still file for a waiver so that they'd be able to continue selling XRP. But think about the implications of that. If they're not approved that waiver, they're no longer profitable. Think about what that means for the XRP ecosystem. The implications are staggering. Do you think Ripple's going to take that risk and just hope that some lowly SEC staff that handles that, the regulatory portion of the things there, do you think they're just going to hope that works out? I sure as hell don't. I'd be shocked. So unless the SEC changes their mind about what they're willing to offer here, if there's a way to work around this, it seems to me, based on what Jeremy stated here, that there isn't going to be a settlement. This thing's going to go to trial, it looks like, and it doesn't mean for sure. And even Jeremy acknowledged, hey, some of this is obviously speculation. Could be that something else is going on here, but that's his honest assessment of what it looks like right now. And so if Jeremy's correct about Ripple being okay with a settlement similar to what happened with Kick Interactive, he cited that this means Ripple is confident that it would have plenty of buyers for its escrowed XRP that are accredited investors, because again, they'd only be able to sell to accredited investors, right? But effectively, consider this though, and this is where I want to come in and share some more of my perspective on this though. Effectively, that's what they were already doing. So Ripple has never sold not a single XRP to any retail investor. So that part actually, that wouldn't be a change. So it's for me, it's easy to see why Ripple would absolutely readily be on board with something like that. And so Jeremy also stated that if Ripple did get a waiver to sell XRP, that purchasers would be required to hold XRP for 6 months. That's a legal requirement. And so check out this. Ripple was actually already requiring timed lockups for most, if not all, of its buyers. So again, all of the buyers, they would have been accredited investors, investors anyway. They were all big companies, this and that. But they were requiring lockups. And I don't know if that was for a legal reason. The only reason that I had known was a factor prior was that they could get a bit of a volume discount, maybe nothing crazy. And some people had a problem with that, and I never did, because I was like, look, you purchase anything in bulk, yeah, okay, you probably deserve a volume discount. But frankly, I don't think that mattered, because while these entities had been purchasing XRP over the last few years, if for most of the last few years, if you held your XRP for 6 months, it was probably worth less than when you purchased it. So even if they got a volume discount, they would probably be in a worse position after 6 months. So I never thought it functionally mattered. Like, you're taking on tremendous risk holding a cryptocurrency, period. So I don't know that really matters in any sort of meaningful way here. But Ripple's got to be able to sell their XRP, or there's going to be some serious problems. Seriously, I'm not trying to scare you, but and I don't think that the SEC, based on what I've seen from attorneys like Jeremy Hogan and John Deaton and many others, it doesn't seem likely that the SEC would win. And in fact, the SEC isn't even trying in their suit to claim that, they're not requesting a declaratory judgment that XRP would be a security, and so a judge cannot rule on that which is not requested. But then you look up to see what Ripple stated, and they're requiring that we get a final verdict in what XRP is. So it's a winner-takes-all thing. Either once this is litigated, either we will have clarification if this goes to court on whether or not XRP is a security, because Ripple is insisting it. The SEC wasn't insisting it, which makes me think, are they really that confident in that type of position? Well, Ripple is, so that instills some confidence in me just to know that that's their position in general. But, as far as the entities that would be purchasing from Ripple anyway, and this is why, of course, they don't care that it would have to be accredited investors, you're talking about market makers. You're talking about on-demand liquidity partners, cryptocurrency exchanges, nothing there would change. And so, from my perspective, that would be perfectly fine. I've just been hoping that there was going to be some sort of opportunity for a settlement, and those hopes are somewhat dashed at this point. So it doesn't mean it won't happen, but if Jeremy's correct in his suppositions here, it doesn't look likely anymore. It doesn't. So again, it doesn't mean that everything's going to go to hell. And I can't imagine a world where XRP is actually declared a security. It's just so nonsensical for so many reasons I've talked about in previous videos and won't delve into in this video. But that's pretty well where we are at to this point. And take a look at this tweet, by the way, from Hester Pierce. This was tweeted out today. This was tweeted out today, 5:05 p.m. And she's at the SEC, mind you. She's an SEC commissioner. She wrote the following, and it was clearly in response to this piece by the acting chair. And she wrote, "We should be able to consider contingent settlement offers in enforcement actions." So she doesn't like that this happened, clearly. Oh man, what a train wreck! I'll tell you what, the SEC, not Hester obviously, but the SEC seems to be largely filled with a bunch of asshats. Even with Jay Clayton being gone, I think there are still a plethora of asshats out there working at the SEC. Oh, man, just stepping on everyone's trip. All right, I'll go ahead and wrap up there, though, but thank you very much for stopping by, my friends. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.